A warm greetings to everyone. I hope I am audible. So the time has approached to initiate an academic session under Project Complete Lawyer. This is Sandeep Chandrasekharan, convener for Project Complete Lawyer, speaking to all of you. We at Project Complete Lawyer intend to reduce the incubation time that is required for a law graduate to become a successful uh, lawyer uh, within a very reasonable time. And the objective that we have put forward is 2 years. By providing them the proper uh, training uh, with regard to the soft skills that is required for a young advocate. And we do this by giving them a proper training through clinical exercises, a series of clinical exercises on an institutional basis. The current institution that we are trying to explore under Project Complete Lawyer is the High Court of Kerala. And the student participants are final year law students from different law colleges in Kerala and different universities. And along with the clinical exercise, which are live cases and past cases before the High Court, trying to analyze the different jurisdictions of the High Court, its powers to provide remedies to the common man. We try to equip the student members of PCL the confidence that they need to do practice in High Court. And High Court is only one of the institutions that we are exploring. There are other institutions created by the law that we will be imparting proper training. And that this training we intend to conclude within 2 years. So along with this clinical exercise, we do conduct certain academic exercise with regard to pertinent landmark judgments. And in a series of academic exercise we have conducted, the Bishop Franco's judgment delivered by a lower criminal court has came to our attention, not only to our attention, but also under public attention. So we have initially conducted an academic session on the Bishop Franco judgment, a legal analysis done by Advocate Ajit Joy, a criminal lawyer himself before the High Court of Kerala. And it was received very well by all the participants, and it was a successful event. This particular session that we are going to have today is a follow-up of that particular legal analysis of the Bishop Franco judgment. Today we are having another academic exercise presented by C. AUNUNANDA and VISMAYA SHAJI, who are working as editors of Ljrf.voice.com. It is an online law journal under Law and Justice Research Foundation. These two persons who are law graduates, they will be conducting another legal analysis, rather a religious and a legal perspective of the Bishop Franco verdict. This academic exercise that we have conducted, these two academic exercise, they are in furtherance of exploring the scope of an appeal before the High Court of Kerala as part of the clinical institutional approach of providing the appropriate training to the student participants of PCL to become successful and confident lawyers on an institutional basis. So any interaction that we will be having today and we had in the previous academic session, they are a personal analysis of the resource persons, and these are an exploration of the legal scope of the particular judgment, an objective analysis, and we do not, the organizers of the session do not intend to hurt any religious sentiments or any sentiments of any individual or a group of individuals. This is purely an academic session to explore the legality of the judgment and its scope for an appeal before a higher judiciary on an institutional basis. With that said, I would like to invite, as the convener of Project Complete Lawyer, I would like to welcome the presenters of today's session. I believe the first presentation will be made by VISMAYA, also AUNUNANDA, and VISMAYA, am I right? You will be making the first presentation, right?
No, sir, it's Ananda.
Okay. Then AUNUNANDA will be making the first presentation. For that, the part 2 of the presentation will be made by VISMAYA. So I welcome AUNUNANDA to initiate the first part of the presentation. AUNUNANDA, back to you.
Good evening, one and all. I hope I am audible and visible enough.
Yes, you are audible, AUNUNANDA.
Okay, just give me a second. Let me present the screen.
Okay.
I hope this screen is visible.
Visible. Yes, the screen is visible. Yes.
Thank you. Good evening, one and all. I am Anunanda, a member of the Law and Justice Research Foundation, Trivandrum chapter, and an editor at the Ljrfvoice.com. And I'm currently a final year student at Government Law College, Trivandrum. Actually, it's my great privilege in being given this opportunity to present a legal analysis on the judgment of Bishop Franco Mulekal versus State of Kerala in this platform. I sincerely thank Safi sir and the entire team of Project Complete Lawyer for providing this opportunity. So without much delay, let me begin. I will keep it very brief considering the time allotted. Before beginning, let me make a disclaimer that this analysis is purely based on my perspective and my interpretation of law and facts of the case, and I have done this by giving due respect to the judiciary. So pardon me for any omission or errors made in the analysis. So let me begin by stating a brief perusal of facts about which you will be very familiar. I hope everyone has at least read the judgment once so that it would be easy to follow. As I have not gone in detail the judgment due to time constraints, I will only be discussing important points. So let me begin. Let us discuss the facts. A complaint was made to the district police chief on 27/6/2018 by the Mother Superior of St. Francis Mission Home, Kuruvalangadu, alleging that she was sexually assaulted and raped by wrongfully confining her on 13 instances within the time period ranging from 2014 to 2016 by Bishop Franco Mulekal, the accused. And an FIR was registered and the concerned magistrate took cognizance of the offence. After investigation, a charge sheet was filed before the first class magistrate court Pala, and the learned magistrate committed the case to the Court of Sessions, Kottayam, under section 209 of CRPC. After the trial, the judgment was pronounced on January 14, 2022, that is recently, and the bishop was acquitted for the want for sufficient evidence. So we'll be analyzing the judgment purely on legal basis as future lawyers and law students, keeping all other emotional and social factors apart. So this analysis will be purely legal and keeping all the other factors apart. So now let's move on to the charges leveled against the accused. So the first charge that was leveled against the accused was Section 342 of IPC. All the charges are under the Indian Penal Code itself. The first charge, 342, deals with punishment for wrongful confinement, as the bishop had wrongfully confined the survivor in room number 20 of the convent before sexually assaulting her in all 13 instances. And the second one is Section 376 clause 2 subclause K, that is rape by a person in a position of control and dominance over a woman. Here, this is very important. This point is very important. That is control and dominance over the women. And the Honorable Court has also considered in detail this point. So we will come to this point later. So please know this point. Now the third one is Section 376 clause 2 subclause N, that is commission of rape repeatedly on the same women, as there are 13 instances of rape. And the fourth one is Section 376C, subclause A, sexual intercourse by a person who is in position of authority or in fiduciary relationship, and he abuses such a relationship to induce or seduce a woman to have sexual intercourse not amounting to rape. So the next one is Section 377, that is unnatural offences, and finally Section 506, that is criminal intimidation. As the bishop had threatened the victim that if she attempts to disclose the incident of offense, then she will be eliminated. So now we'll move on to the peculiarity of the case. I personally found some specialty or peculiarity in the facts of the case and also with regard to this case, and I have just summed up those points. The first one is the survivor is a nun. The importance of this is that the survivor is a nun who has taken the vow of celibacy, for whom this vow is of paramount importance, and she is someone who is existing within the hierarchical male-dominated congregation, to whom raising voice against superiors was not at all easy and needed utmost courage. And the second important peculiarity is that the accused is the spiritual head of the congregation. He had administrative and spiritual control over the victim. He was in a position of trust and authority. The next point is the most important point. There is a huge delay in lodging the complaint. The complaint, as you know, was filed in the year 2018. That is almost after 2 years from the last incident of sexual assault alleged by the survivor. And the fourth important point is that neither in the FIA statement nor in the 164 statement given to the magistrate, there was a specific allegation, express allegation that she was raped. So this is a peculiar factor. Now let's move on to the next slide. Before moving on to the analysis, it is very important to keep in mind these fundamental principles of criminal jurisprudence with regard to Indian law. The first one is obviously that a criminal case has to be proved beyond the shadow of reasonable doubt for an accused to be convicted. And the second one is the benefit of doubt is always in favor of the accused. So this is the fundamental principles of criminal jurisprudence in India, and this has significance in this case also. So now we'll move on to the next slide. That is, there are some questions formulated by the court. There are so many questions about which I will not be dealing every question or discussing every question. I have chosen some important questions, so we'll be discussing only that. So the question formulated by the court has been mentioned in paragraph 45 of the judgment. So some of the main points are: the first one is it proved that the accused was a person in authority, or that he is in a position of control or dominance over PW1. So as I stated earlier, this is an important point. The court has in detail addressed this point, and the court has been satisfied by ample documentary and oral evidences that the accused was exercising real authority over the congregation and the nun. He is definitely a person in authority. This point was held in favor of the prosecution. But the point to be noted here is, this point is relevant only when it comes to punishment for rape and has nothing to do with the question whether rape was committed. I'm sorry, I guess my video was off. I'm really sorry. So let me continue. As I told earlier, this point was held in favor of the prosecution. But still, but the point here which is to be noted is that this point is relevant only when it comes to the punishment for rape, and it has nothing to do with the question whether the rape was actually committed. It has nothing to do with proving the offense of rape, but it has relevance when it comes to the punishment of rape. And this question has also relevance in explaining the delay to lodge the complaint before the police. Now, the second important question is that, is there any delay in lodging the complaint? If so, has the prosecution explained the delay? And the third one is, has the delay caused any prejudice to the accused? Now, the fourth one, has the prosecution proved that the accused committed rape on PW1, repeatedly making use of his position of trust, authority, and post of control and dominance over PW1, and thereby committing the offences punishable under Section 376, subclause 2, clause K and N. So these are the points. So the rest of the 3 points I'll be dealing together while I'm discussing the appreciation of evidences. Now let's move on to the next slide, that is appreciation of evidence. So there were so many evidences produced before the court, and I'll not be going in detail or discussing about all the evidences. I have just put some important evidences for the purpose of discussion. So the first one is the testimony of PW1, the victim or the survivor itself. The testimony contains the description of time, date, occasion of Alice's sexual assault on 13 instances. The deposition made in the court is clear and unambiguous as to the offence committed, but what the court found fault was that in the disclosure, the court found fault was in the disclosure in the FIR statement and 164 statement, and to the disclosure to the companion nuns and to the doctor. So it is an established principle of law that there is nothing wrong in holding a man guilty relying on the solitary evidence of the rape victim itself. So this legal principle has been discussed and formulated in many of the Supreme Court cases. The Supreme Court has held in favor of this point. So I'll be discussing some of the important cases. The first one is Wahid Khan versus State. The citation has been shown in the presentation. So it was in that case, it was held that in the case of rape, testimony of a prosecutrix stands at par with that of an injured witness. It is really not necessary to insist for corroboration if the evidence of the prosecutrix inspires confidence and appears to be credible. Here the phrases inspires confidence and appears to be credible should be noted. In another case, that is Krishna Kumar Malik versus State of Haryana, the Supreme Court again observed that to hold an accused guilty of commission of an offence of rape, the solitary evidence of the prosecutrix should be of sterling quality. So the doctrine of sterling quality, this principle formulated in this case. So, and what is the sterling quality was explained in Deepu versus State. The court regarding the quality of sterling witness held that what would be more relevant would be the consistency of statement right from the starting point till the end, namely at the time when the witness makes the initial statement and ultimately before the court, statement before the court. It should be natural and consistent with the case of the prosecution qua the accused. Here the court has observed that there is no consistency in the statement of the victim and she is not a sterling witness because she had not disclosed the whole of events to in the FIR statement, nor in the 164 statement, also to PW2, that is Sister Lissy Varakel, and PW3 Sister Nina Rose, and also PW4 Sister Anupama, and the prosecution has miserably failed to explain the inconsistencies. Thus, the Honorable Court was forced to look for corroborations under Section 157 of the Evidence Act. But in my opinion, the chain of circumstances leading up to the first instance of offence is laid on clearly on the sole testimony of the prosecutors, also with the corroborating evidence of the prosecution witnesses ranging from PW2 to PW11, and also the alibi of the accused was not accepted by the court. So here it is important to note a case in state of Punjab versus Gurmeet Singh, which is a case in 1996. In this case, the court held that in cases involving sexual harassment, molestation, etc., the court is duty bound to deal with such cases with utmost sensitivity. Minor contradictions or insignificant discrepancies in the statement of the prosecutor should not be a ground of throwing out an otherwise reliable prosecution case. So this just keep this case in mind. So here, so in my opinion, the trial court could have viewed the circumstances and mental condition of the survivor in view of her position under the hierarchical system more empathetically and justify the omissions and minor discrepancies in the FIR statement and other disclosures. As you can see, there are no major contradictions. There are only certain omissions in the FIR statement as well as in the 164 statement. There's no as such major contradiction. There's only omissions in those statements, and the victim has fully given the version in the court. So now let's move on to the next one. That is the next important testimony. That is the testimony of PW2 Sister Lissy Vadake. This testimony is very important as far as corroboration under Section 157 of the Evidence Act is concerned. The sister Lissy Vadake is the spiritual mother of the survivor. PW1 had disclosed about the incidents of offences that she was subjected to during 2014 to PW2, and the same was duly corroborated by PW2 in the Honorable Court. Actually, this itself is enough to convict the accused, as one instance of rape has been corroborated and sufficiently proved, and the court need not go to the extent of strictly proving the subsequent instances of rape. But what happened here is the court disregarded in toto the testimony of this important witness, that is Sister Lissy Vadake, PW2, on the following reason. There are so many other reasons also. I'll be pointing out two main reasons why the court disregarded the testimony of the witness. The first reason was that PW1 did not disclose the future incidents of rape after 2014. That is, the incident that occurred after 2014 was not disclosed to PW2, and the court assumes that normally she should have reasonably done it, as she is like a mother. That is, PW2 is like a mother to PW1. And the second one is also because the disclosure to PW2 was not mentioned by PW1 in the 164 statement as well as FIR statement, which again the court assumes that she would have reasonably done. Also, both PW2 and PW1 did not speak out until 2018. This has been duly considered by the court and given importance to disregard the testimony of PW2. Further, the court's opinion that the probative value of the statement made to a non-authority, that is here it is PW2, gets reduced by the lapse of time. So now we'll move on to the next testimony, the important testimonies, that is testimonies of PW3 and 4, that is Sister Nina Rose and Sister Anubama respectively. The other main corroborative witnesses are that is PW3 and PW4 had deposed in the court during the trial that they were informed by PW1 regarding the sexual assault on several instances after the retreat at Attapadi in the year 2016. However, this is in contradiction with the interview of PW4 to DW4 in the Media One channel and a letter wrote by PW4 to Mother Superior Sister Regina, as in the letter was dated 14/11/2017. That is after the retreat from Attapadi. That happened in 2016. So in this letter, she claims to be unaware of the actual issues between the accused and PW1. And in the interview, she told that PW1 that is disclosed to her that PW1 will be forced to sleep with the bishop, and not that she was actually raped. And also she knew the incident only after the FIR statement was filed, that is, the complaint was launched. So PW1 also uses the same words in her FIR statement that, and in the 164 statement, that she had deposed to PW3 and 4 that she will have to sleep with bishop if he comes, and not that she was sexually assaulted or raped. So now we'll move on to the next important evidences, that is the exhibit prosecution, the exhibit submitted by prosecution, that is exhibit number 55 and 56, that is a medical report of the victim. The court, with regard to these evidences, noted that the victim did not disclose about penile penetration to the concerned doctor. Please note here, it is also to be noted here that penile penetration has also not been mentioned in the SIS statement. So now let's look into a provision that came after the amendment of 2013. In 2013, considerably the rape laws were amended, and there are certain provisions which are inserted. So with regard to the definition of rape, in section, it was given in section 375, and what is relevant here is clause B. The thing is, if a man is said to commit rape, if he inserts to any extent any object or a part of body not being the penis into the vagina, the urethra or anus of a woman, or makes her to do so with him or any other person. So it is clear that the absence of penile penetration also amounted to rape. But the problem which occurred here was, subsequently, the medical report was corrected or altered, which again left the court with no choice than to unrely solely on the fabricated report. So these are the important evidences. Now we'll just slide on to the other aspects, other factors which which affected the judgment on the case. The first one is Jaya's complaint. Jaya was PW16, that is the first cousin of PW1. And here an interesting development in the case occurred, that the Jaya had lodged a complaint to Sister Regina that her husband Anandan and PW1 had illicit relationship. And the defense alleged that PW1 is falsely accusing the accused to cover up her immoral conduct, as the bishop had initiated investigation with regard to the complaint. It was also alleged by the prosecution that the bishop was behind the complaint of Jaya. But it was proved in the trial to satisfaction of the court that the bishop had nothing to do with the complaint. But the thing is, later Jaya itself acknowledged in the court that it was a false complaint, and she did it out of rage. But unfortunately, and to my surprise, the honorable court disbelieved her confession that she made a false complaint. That the confession before the court that she made a false complaint before and considered the complaint to be true, and stated that these are the words, these are the lines stated in judgment. I'm reading that. The exact words, I'm reading the exact sentences. If the issue was so trivial, there was no need of PW16 to take so much of pain to inform the matter urgently. PW16 is not an ordinary housewife. She is a teacher in a private school of Delhi, and her husband is a lawyer practicing at Supreme Court of India. The conduct of PW16 has to be appreciated in the said background. So the irony that I found here is that, on the other hand, the court chose to disbelieve a nun who has dedicated her life in the name of God. So this is an irony I found here. So in my opinion, the court has gone unnecessarily into examining the genuineness of complaint filed against the nun by Miss Jaya, as if to target the chastity and to examine the sexual history of the victim. There has been a ample of discussion with regard to the complaint. So I felt it a little bit unnecessary. Now we'll move on to the next point, that is weakness in part of the prosecution. It is very clear that the prosecution has miserably failed to prove the case beyond reasonable doubt. Here the prosecution has also failed to produce the main weakness with regard to the prosecution case was that the prosecution failed to produce important evidences such as the survivor's mobile phone, laptop, which would have considerably contributed to the prosecution case. Also, the electronic record containing the laptop of the accused was not properly certified or authenticated under Section 65B of the Evidence Act by the police, and thus all or most of the electronic records in the case was disregarded by the court. And also with regard to the tax receipt, only a Xerox copy was submitted. So the prosecution has done all these things which have contributed to weakness inside of the prosecution. And here it is evident that by reading judgment, the police has tried hard to create a foolproof case, which is clear from the correction of medical records subsequently and in supplementary statements of the victim and key witnesses. So now we'll move on to the next aspect, that is the most important thing, that's delay. The complaint was, as you know, lodged in 2018, and here the defense argued that PW1 was uh, had started raising voice only after Jaya's complaint and kept mum for 2 long years, which itself makes it liable to be looked upon with suspicion. The court has concluded that the prosecution failed miserably in justifying the delay to the satisfaction of the court. Here, the court has relied upon the judgment. That is, Ramdas and others was the state of Maharashtra. It is a settled law that, however similar, before that, let me say that actually, in cases of rape, delay normally is not considered as material, like the delay in lodging the complaint, as considering the social, family, and mental circumstances of the victim who has been raped. So, like the court considered the relied on the judgment of Ramdas and others of the state of Maharashtra. It is settled law in the case it was held that it is settled law that, however similar the circumstances, facts in one case cannot be used as a precedent to determine the conclusion on the facts in another. Thus, mere delay in lodging of the report may not by itself be fatal to the case of the prosecution, but the delay has to be considered in background of the facts and circumstances in each case, and it's a matter of appreciation of evidence by the court of the facts. So the court basically is trying to say that based on the facts and the explanation given by the court is not satisfied that the delay is justified. So in this case, it is to be noted that the victim here is a person who has given her entire life to the church and the vow of chastity. Even raising such an allegation will have disastrous consequences in her life, considering her position and the accused position as he is the spiritual leader of the congregation. It was also proved beyond reasonable doubt in the court that the accused enjoyed a position of dominance over her, which could have also resulted in the delay in lodging the complaint. It would have taken great deal of courage and struggle to come out and explain the ordeals she had to face, that she was subjected to. The same applies to the other nuns who stood in solidarity with survivor. So, we always see trial judges to understand the circumstances. Unlike the other judges, the judges in the right court try to understand we expect the judges to write the circumstances and to think from the part of the victim. In my opinion, the court could have empathetically and more liberally considered the factors explaining the explanations given for the delay. So, and before, let me also, it must be pointed out that the counsel for the defense was successful in dissecting and examining minutely each sliver of evidences brought by the prosecution, pointing to its discrepancies and making their side stronger. So, having said that, I should say that I failed in forming an opinion as to the correctness of judgment, as I was stuck between 2 points. The first one was that the court could have only come to such a conclusion having given the nature of materials before the court. The second point was that the court could have more empathetically scrutinized the testimonies of the nuns, considering their circumstances before rejecting the testimonies totally, as it is a sensitive case of rape. So between those points, I really failed to form an opinion as to the correctness of the judgment. So now let me go into the scope of the case in the High Court. The court has, as you know, while it is clear from the judgment reading that the court has disregarded the important testimonies, applying the maxis falsus in uno, falsus in omnibus, which means false in one thing is false in everything. So first, the High Court will definitely consider the application of this maxim in this case. But the Supreme Court has, in Prem Singh and others versus State of Haryana, held that the doctrine falsus in uno and falsus in omnibus has no applicability in India. And further, in Jayashilan versus State of Tamil Nadu, the court observed that the doctrine has applicability where it is not feasible to separate truth from falsehood because grain and chaff are inextricably mixed up, and in the process of separation an absolutely new case has to be reconstructed by divorcing essential details presented by the prosecution completely from the context and the background against which they are made. The only available course to be made is to disregard the evidence in toto. But here in this case, considering the evidences, I don't uh, I don't have the opinion that a new case has been formed. As mentioned in the judgment, it is necessary to apply the maxim. There is no formation of an absolutely new case, but it is true that the separation of grain from the chaff appears very difficult. So if the prosecution can present their case with more clarity and in a more convincing way, solving all the discrepancies that arose, there is scope for conviction of the accused. Now, let's deal look into the reappreciation of evidences. Also, in such a case, the High Court will have to reappreciate evidences as much as so much of evidences has been disregarded by the trial court due to inconsistencies and discrepancies. So, with this regard, in Chandrappa versus State of Karnataka, 2000, it was a case in 2007. The court reiterated the legal position that an appellate court has full power to review and reappreciate and reconsider the evidence upon which the order of acquittal is founded. And also, the appellate court, however, must bear in mind that in case of acquittal, there is double presumption in favor of the accused. First one is of course, the presumption of innocence, which is available to him under the fundamental principles of criminal jurisprudence, and every person and every person shall be presumed to be innocent unless he is proved guilty by the competent court of law. And the second one is accused having secured his acquittal, the presumption of innocence is further reinforced, reaffirmed, and strengthened by the trial court. Thus, the prosecution has to uphill a battle in front of the appellate court to primarily convince the court that the evidences need to be reviewed, reappreciated, and reconsidered. Further, in state of Rajasthan versus Naresh, it was held that an order of acquittal should not be lightly inferred, with even if the court believes that there is some evidence pointing out the fingers towards the accused. So the order of acquittal should not be considered lightly. That was held in this case. So even if the evidences are reappreciated, the prosecution will have to convince the court that there are more important evidences that points to the guilt of the accused. Then there are chances of the accused being convicted. So that's all. Let me conclude here. And once again, I thank the organizers for giving me this opportunity. Now, my learned friend Vismaya will be presenting the religious perspective of this case. So thank you, one and all.
Thank you, Anananda. Thank you for the presentation. Without any delay, due to the lack of time, I invite Vismaya to initiate your presentation. Anananda, can you stop your presentation so that Vismaya can start her? Yeah. Vismaya?
Yes, sir.
You can start your presentation.
Okay, sir. Thank you. First of all, it's a great pleasure for me to be here. And as my friend already stopped there, I would like to continue from the very first question, that is the control and dominance over the none. So for that, please give me a minute. I want to share the screen.
Dear participants, meanwhile, I just want to remind all of you again, this is an academic exercise, an objective one at that. We are trying to analyze the scope of an appeal before the High Court as an institution. As Project Complete Lawyer, we are trying to impart soft skills and other techniques of practice to law graduates, young law graduates, to equip them to become a successful lawyer at different institutions like the High Court. So for that purpose only, we are conducting this session. And please analyze and perceive these interactions that we will have in an objective manner, and we do not intend to harm any religious or minority values. Okay, this is a full disclosure. Miss Maya, you may
Yes,
begin.
sir. Is the screen visible?
Yes, yes, it's visible, Miss Maya.
Okay. So, in this case, the very important question in religious aspect is the dominance and control over the nun. So, whether this is true or not, to get to know that, we need to analyze the religious aspect of this case. So, the first question, that is the fiduciary relationship. The fiduciary relationship between the nun and the pope, the bishop, sorry. Uh, to get to know that, we need to look the hierarchy, that is the hierarchy of the Catholic Church. In this, it is very clear that where the monk and the nuns are, and the priest, then the bishop, and the cardinals, and the pope. As per my research and all the internet sources and personal research information, I got to know that the subordinates in this church, or the nuns or the monks, are blindly needed to follow their superiors, and this is so pathetic, as I think, because this it's not something that I am commenting to hurt any religious or the something emotional of anybody, but it's just about my personal opinion. Then the heart of fiduciary relationship, that is basically lied on the dominance and the control. Then and the de facto, that is the de facto control, dominance, and reliance. Then going up to the next, that is what will happen if this case, in the same case, if it was against an ordinary man, not a bishop. Give me a minute. Just because this is not a normal rape case, both the parties involved in this case are part of the church, who even came to know each other only because of the religious role. We know that this bishop and the victim, that is the nun, came to know through the religious aspect, to the church basis, which is another important aspect of this case, because they are not normal people or not normal ordinary citizens, because they have the religious commitment and or as well as the legal commitment, and which even raises the question about the integrity of the church. Then about the parties in this case, the Bishop Franco and the victim of this case, who is a nun, was the Mother Superior of Kuruvelangadu Convent, that is Missionary of Jesus. From this very brief introduction, we can understand their important roles as the pillars of Catholic belief. The commandments then about that is about the nature of parties involved in this case. Then the fundamental elements and foundation of Christianity. The fundamental elements and the foundation of Christianity, that is commandments and the grace and truth of God, are the fundamental concept or the foundation of Christianity. A brief history of the corruption and corruption allegations against such man in power. So a very good example for this, I think, is the Pope Alexander the Sixth, which is notoriously famous for his very famous for his narcissistic and his family background, plus all the corruptions he made in his period. Again, this is just based on the historical facts. I'm not intended to hurt anybody's religious or emotional aspect. Then, church, the body of Christ. So, church is normally can be described as a place for gathering for prayer, but more than that, the church is the body of the Christ. But is then the duties towards God and church is so important. And who is a bishop? The bishop is one of the most closest or the most important person in the hierarchy of church, and he is somebody who should be a role model to all the persons in those who follow his belief. Then the authority of such person is we all know that how much authority or how much powerful this institution is. And I believe that the bishop is somebody in between in power, just below the cardinals. And then after the cardinals there is a pope. So how much power that person is holding is very clear. And from this, the righteousness of this person is at maybe in question, because righteousness from a man of the church is very important. But in this particular allegation based on this case, that is at question. And the misuse of this authority, he is having a very powerful authority, and that authority, the misuse of that authority is unforgivable in the eyes of God, I believe so. And as per the Bible, it is like that. As per the discussions and the advices I got, it is like that. And what was the aim behind creating the church? The aim behind creating the church is just simple as it is. That is, church are meant to help people to be a good person, to be righteous, to be more truthful person in his personal life, and to be somebody who follow the Christ. The one who follows the Christ is somebody that person is known as Christian. Then Bible's disabled Peter. I think most of us are very familiar. The picture here is also of the Peter, the disabled Peter, who was the first pope. Then, who is a Christian? This is the very most important question here. A Christian is someone whose behavior and heart reflect Jesus Christ. The follower of Jesus were first called Christians, and the Act 11:26. For a whole year, am I audible?
Vismaya, you are audible.
Okay,
You
sir.
are audible, Vismaya.
So,
Go ahead. Go ahead.
okay,
Yes,
sir.
yes.
Thank you. The disciplines were the Christians. The disciplines were first called as Christians in Attonich. They were called the Christians because of their speech and behavior were like the Christ. So, somebody whose behavior and speech are like Christ is known as Christians. Then, it is also very important to note the power that the church hold, and the church is something that is considered as the embodiment of God. Then, because the head of the church, that is the persons of this church who are in power, who are the people we consider as the embodiment of God. Then, the three dimensions of being a Christian. The three dimensions of being a Christian include one's faith in Christ, being the followers of the Christ, and the real discipline of the Christ. So the dimensions of being a Christian consist of faith, followers, and this, as per the Holy Bible, there is a condition put by the Christ himself that says, "As you please as you please take the cross and follow me. This was said by the Christ. Then here the cross is a metaphor for hardship in life. The real disciplines, it is the most interesting part of this. The real disciplines include the 11 followers of Christ and also the follower of their followers, and which even include today's pope, priestess, and bishop. Then holiness, righteousness, and obedience to the God is important to be a real discipline. So a person who loses this holiness, righteousness, and obedience to God cannot be considered as a real discipline. Then the 10 commandments, grace and truth. I already mentioned about the fundamental concept and the foundation of Christianity. Not only Christianity, that it is most important for those people who are in the church. I mean, the man or the persons who are holding the authority of church. The 10 commandments you can already see here. The Lord, I am my God. You shall not have other gods, believe me. And all these 10 commandments, I am not going to read all this. But moreover, a person all these persons, all these bishops, all the nuns are taken oath to be obedient, to be righteousness, to be of righteousness and truthful towards God, the laws of church which was given by Moses, and all these things. Then the happening of violation of God's desire. The violation of God's desire. It's not quite clear in this case, because we don't know what the actual truth. Anyway, then the biblical punishment for such violation it's something very evil if it is. I am not going to say somebody is wrong or somebody is right. Here we can take things in just like one on one, because if the one person is the first person, if the party A is saying something about something which is not right or which is really untruth, then that means the punishment as per the Bible is that person is something of evil, and the punishment is that person may get abandoned by the God. And same in the other case, if it is not, it's like we don't know actually what the truth is, right? Then the church cannot change the law of God. We all know that the law of church was not actually given by the God, but it is said that it is derived from the teachings of Jesus, and the teachings that he want to teach us through that he wanted to teach us by being here in the earth, that he gained from his Father. We all know the Trinity, that is Father, Son, and the Holy Spirit. Then that, and the other important thing is, whoever is wrong here, the church cannot protect that person, and that for that person the church cannot change the law of God or that is written in the Bible. Then one who lost the holiness is someone who is against the God, law, and every ethical, moral, religious aspect of Christianity that I have already just told now. Then when you are against the truth, then you are against the Christ. That is so simple, which I don't know when we will get to know about the final truth, but as researching this religious aspect, what all I understood is just like in a nutshell, it is if the person who have done the wrong will this person who have done the wrong is considered as something evil, who did something evil deed, and that person is simply against the truth, and which means that he is against or she is against the Christ. So that's all about my presentation here.
Vismaya, thank you for the presentation. I believe in summary, Vismaya was trying to explore the religious aspects, the religious corner, which might have facilitated a possible um fiduciary relationship between the bishop and the nuns, and the possibility of the bishop the bishop being the nuns being under the control of the bishop, under the rule of the bishop, and the difficulty of the nun to go against the bishop or make any claims against the bishop, how difficult it is because of the religious customs and traditions, or the interpretation of the Bible as such. That was the point that Vismaya was trying to convey, I believe, in connection with what
Yes,
Anunanda was making. That is the power of the bishop over the nuns, and how difficult it is for the nuns to overcome that power or to go against that power if it is abused. That was the point that Vismaya and Ananda was trying to convey. A pertinent point again. Nevertheless, again, it is an analysis that was made by Vismaya and Ananda based on their research, which they have done to the best of their ability and best of their knowledge, along with others on ljrfvoice.com. Thank you, Vismaya and Ananda, for your presentation, wonderful presentation. We will have 5 minutes for question and answer session. I believe the time that is the time we have, unfortunately, due to the limitations that we have. So, any questions, anyone? Apologies again, because it is not easy to convey the complexity of religion as well as the legal aspect in this very short time. But that this is all we have for the time being. So, any questions from the participants? Five minutes we have again. If there are questions, you can also post those questions through email. You kindly note down the email, completelawyer 2020@gmail.com. If we will try to collect all the questions that may come and post it to both Anunanda and Vismaya. Okay, I believe there are no questions. So I thank the resource persons, both Anunanda and Vismaya, editors of
Sandeep, I'm
Gino.
Gino.
Gino, yes, please. Kindly
Sandeep,
introduce yourself first and before raising the question.
yeah, myself Gino, I'm Korean. I'm also part of LJRF and law exams. Just a comment. When I saw this particular topic, that's the reason why I just joined it.
Okay.
I mean, when I see this religious aspects, when we consider this particular bishop and all other bishops, one of the important thing what religion says, as well as the believers say, believers has this particular thought that they are having a celibacy of their life. I mean, they are devoid of all the worldly affairs. So Vismaya, I mean, my concern is like how religion is trying to see this. So he is in a way he is admitting the fact that he is not like such a person. He is,
yes, sir.
isn't it? So how religion is trying to see this particular thing? He admitted that fact. Like I am not a kind of person who is devoid of these kind of things, but he is saying like he consented and he I mean, he consented to do that particular thing, what he did, right? That is what the case says. I mean, he admitted that particular fact, like he, I mean, did the relationship with the other person
Okay.
consensually, right?
Mhm.
He gave the consent, and she has also given the consent. But this is not the fact like a religion says, right?
Yes.
Religion believes that bishops are like people who are
Who
not
should
having
cherish their
right?
virginity, both the bishop and nun. If they are gone against the oath, they should be, they are supposed to give an oath when they are given that responsibility. So if they went against that oath, they should be willingly give away the responsibility and go back, or otherwise they are seen as it is seen as something evil deed from their part.
Yes, Vismaya. I mean, I just want to point out that particular thing, like how religion is trying to see this, still keeping him as one of the bishops of their church. At the same time, he is admitting the fact that he did certain things. I mean, whether what is the judgment or whatever it was held, that is a different thing. But on the other side, what the defense he made like consensually he has given certain or he has done certain things with another person. So whether this is something a religion can accept.
No, it cannot accept, it cannot even consider this kind of act from a bishop.
I'm not
He
questioning you. I'm just sharing my comments after viewing and listening to various comments from various point of view. So I am having this particular thing. How religion is trying to see this. Anyway, at the end of the day, Christianity is something like they always say, like forgiveness. So definitely they will be forgiving to everyone, including this particular person also. But this is something we need to point out, at least about the purpose of discussion. I thought to share that. Thank you.
Thank you, sir.
Jinu, so
Yes, yes,
with your permission,
yes,
sir.
Prashant sir. Yes, yes.
Sandeep, with your permission, yeah.
Yes,
Jinu,
yes.
I don't think you are entirely right in saying that the bishop admitted to doing it and tried justifying it by saying there was consent. I think that is a wrong factual submission. Maybe our first speaker, uh,
Anindanta.
Anunanda, can perhaps correct us on this. I don't think that's correct. I think the bishop simply said nothing like this happened. You prove that it happened. If you prove that it happened, then only there is a question of justifying it based on consent or otherwise. I don't think it got to that level in the first place. He simply denied that something like this happened, and even the judgment only dealt with a situation where whether at all there was evidence to show it happened or not alone had to be discussed. Of course, it discussed about the hierarchy, but nothing had to be taken forward from there because a hierarchical discussion is relevant only if you're discussing consent. It didn't get to the point where it had to discuss consent because it never went past the point where whether it happened in the first place or not had to be answered against the bishop.
Sir, but there was a question like, was there the dominance and actual control over the nun due to his authority over her?
That's right. That's what I'm saying. So what I'm saying is this. Now, Anunanda can correct us. Of course, we are having
Yes,
an
sir.
academic discussion. But Anunanda,
Uh,
tell us this. Now, what is being asked is a very important question. You know, when somebody says raped 13 times, right?
Yes, sir.
One of
Yes.
the automatic conclusions can be then there is no rape. That can be one of the automatic conclusions. The moment you say raped 13 times, there is no rape. That is the issue where the law looks at consent. But here it never went to that level.
Yes, sir.
Because whether raped even once, okay, 13 times, whether raped even once is an issue which the court considered and held in favor of the bishop. So raped 13 times was not factually proved. Therefore, the next level of determination being whether that was with consent or without consent was irrelevant, because whether it happened in the first place or not, factually was never proved in favor of, or let me say, put it reverse, was never proved against the accused. Am I reading it wrongly? Because I have only cursorily seen the judgment. Anunanda can tell us if I am wrong on this. This is my impression.
Sir, let me interrupt. Sir, what you told is absolutely right. Here, the court has only first assessed whether the rape has actually happened, and only if the rape, if it is proved that rape has happened, then only the court in the next level goes to see or assess whether there was consent or not. So here the court has not reached that level. As in the first instance itself, there was no evidence to prove beyond doubt that there was rape. So, and also the bishop cannot cannot acknowledge that there was that he had any sexual intercourse or anything, because because he is a bishop, and
Because
he
he's a
cannot
bishop.
yeah.
Correct.
And
correct.
there's no acknowledgement in court that there is nothing. There's no acknowledgement as to he had any sexual intercourse. And also, if the question of consent comes also, in my opinion, that the question has no relevance, because the accused has dominance over the victim, and it will be only post consent.
No. So, Anunanda, I'm not getting there. That's a separate thing. Now, that you're right. When you come to that stage, what is consent becomes a very tricky issue. Now, that's a very tricky issue, not only in criminal law, but also in, let's say, civil law, contract law, for instance. Is contract vitiated by undue influence, fraud, mistake of fact, mistake of law, and there are several other public policy considerations under 23. And what does the court get to when you look at all this? The court essentially looks at the respective bargaining positions of parties and the difference in the hierarchical structure and bargaining positions. For instance, I am a corporate lawyer. I practice in Bangalore. I'm a corporate lawyer, meaning my clients are corporate clients. We cannot often argue this problem of lack of consent, for the reason that Supreme Court has laid down, and many other courts have laid down consistently, that when two businessmen enter into a contract, it is understood that they were advised well. It is understood that they knew what they were signing for. It is understood that there was consent there was informed consent. Whereas if people are in differential bargaining positions, for instance, when I deal with employer-employee disputes, there the Supreme Court is very clear that merely because you have asked an employee to sign on dotted lines and he has signed, it does not mean that he knew what he signed or he bargained for what he signed. He didn't have a voice there often. So that is very clear that if you get to that level, you will need to see whether consent is there, consent is not there, what is the position. Where, see, merely because two people are in hierarchical position, it doesn't mean that one will necessarily have to be seen as bulldozing the will of the other. See, for instance, I'll tell you, somebody may today say that a nun, being a nun, is in a closed ambience where she possibly does not have a ventilation for her grievances. Another person may say that, look, nuns run social institutions, nuns run hospitals, nuns run educational institutions, nuns are the ones who interact with the society the most. They are not a closed society at all. They interact with authorities, they interact with parents, they interact with patients, they interact with doctors, they interact with teachers, they interact with lawyers. It's a perception. One may say they are in a closed society, another may say they are in the most open society. That's a question of fact. And who is this nun? Is this nun somebody who is slightly lesser in the hierarchy, or was she reasonably placed high in the hierarchy? These are all questions of fact. We don't need to get into answers today. But what I'm saying is, when it comes to a question as to consent, it becomes very complex. One, parties are in two different positions. And two, even if they are in two different positions, it does not always mean that one will bulldoze the other. Because even then it becomes factually very complex. So that is a separate discussion altogether. Merely because, yes, they are in differential position, that means one has dominated the will of the other, may not be correct. it just cannot be correct. And that is why in the last discussion, Ajit sir was referring to the Tehelka incident and things like that. But in any case, the question today is this. The question today is whether this public perception that our friend Binu, right? What's his name? Our friend who raised the question.
Gino, sir.
Gino, sorry.
Yes,
Our
Gino.
friend Gino's, it's a very important thing for all of you to know. See, our friend Gino's question is a common misconception that people have, because we are all going by newspaper reports. Going by the newspaper reports or going by preconceived notions, you tend to believe that maybe the judgment suggested that there existed a relationship between the parties, and occasionally they gave into physical intercourse. But that's not the case. The judgment just does not discuss a relationship at all, because the bishop never justified saying there was a relationship. Rather, he said no sexual intercourse occurred. You prove sexual intercourse occurred. So
Yes, sir, that's true.
So, Gino, you must know this. You must know this, that the church is still able to tolerate him because he never made a confession that it happened. You're right in saying texture would have completely changed, and possibly, the brigade would have seen him very differently.
Sir, Safi Mohan here.
Yes,
I
sir.
think Gino asked a hypothetical question. I think is it right, Gino? Because Gino said if he is admitting the fact that he committed the wrong, and what would be the position of church? I think that kind of question he asked. Is it right, Gino?
Yes, sir. I mean, maybe I have presented it in a different way. That's why.
Yeah. So you asked a hypothetical question. I think you asked a hypothetical question because of the reason that there is an element of forgiveness, which is also an integral part of Christianity. Am I right?
Yes, sir.
So actually, I think it is my opinion is that we have to distinguish who have faith in Christ, because I think it is simply explained by Vismaya that in Christianity or in the Bible there is a three important concept, that one who have faith in Jesus Christ, and one who are the followers of Jesus Christ, and third thing is with the disciple of Jesus Christ. So actually, the person who have a faith in Jesus Christ means anybody can be a faith in Jesus Christ. So, for example, I have faith in Jesus Christ because somebody said that there is a Jesus Christ who lived in before and he was a great God. Then I automatically have faith in Jesus Christ. That is the first criteria. And second criteria is the follower. Yes, followers. As Vismaya mentioned, where we can see who is a follower. So, who is a follower? Follower means who take the cross. So, what is the qualification that required for a follower is to take the cross. So, for example, then the important question is who is a disciple. So, the disciple means in order to be qualified as a disciple of Jesus Christ, I think the same Bible saying two conditions. One condition is you have to love Christ, and second condition is you have to keep his commandments. So I think the bishop is actually in a position of a disciple, so that he has two important religious duty which has been imposed by the Holy Bible. One is to love the Christ, and second thing is to keep his commandments. So the important question is whether he failed to fulfill this. The answer is yes. He failed to fulfill this condition. So he is actually not an ordinary Christian who have faith or who is following the Christ, but he is actually a disciple. So that is one of the reason why there is no fundamental difference between Christ and a bishop, because both are one and same, because of one of the most important fundamental doctrine which is there in the Bible, which is one of the fundamental foundation of Christianity, which is born again, the doctrine of born again. So, that concept is itself saying that there is no fundamental difference between Christ and a bishop. If he is a born again, then the question of repentance does not exist.
Okay, sir. Apologies
I
for
have a
interfering.
point.
Yes, Johnson, sir, yes.
I think that under the Christianity, once a bishop, always a bishop. Once a priest, always a priest. And you may relieve him from the duties that he discharges. Maybe you may say that on finding certain things against him, you may say that you need not continue to be the Jalandhar bishop or something like that. Nothing more than that. You cannot strip him of his bishophood. He will continue. Even the Pope cannot do that. So that is how it works. So we need not have a perception that if some findings are there by the judges in a judgment, immediately the church will take note of that and strip him of all his, including the. That will not happen. It's a way of life, and whether you continue as these official duties or not is a different issue altogether. That's what I understand. Thank you.
Thank you, Johnson, sir. Thank you, Safi, sir. Thank you, Johnson, sir. Thank you, Jino, sir, and Prashant, sir, for your point of views on the subject. All the point of views are opinions, and we have that has been raised from the presentation of the resource persons, and we definitely had a good discussion on the subject itself. Thank you for your valuable perspectives. We have unfortunately ran out of time. On behalf of Project Complete Lawyer, as the convener, I'd like to thank the organizers for the wonderful session. I also thank the participants for their patient hearing and expression of their point of views. So the session has been concluded, and I convey a warm and good night to all of you. Take care. Take care, everyone.